Yeah, I just wanted to say another category of cases we haven't discussed here that in some courts almost never appear on the public docket is that of material witnesses. And in the period immediately after 9/11, there was a huge spike up in the use of the material witness provisions by the Justice Department. I think many people would argue that it was being used as a mechanism to detain people who were actually suspects, just when the government didn't have enough evidence to charge them. They were just handled in an incredibly disparate way depending on what jurisdiction you were in. The mechanism was used in the case Henry mentioned earlier, the Oklahoma City bombing, but in that case the proceedings took place in open court up in New York with Judge Mukasey. He said not only wouldn't we learn about it now, we were never going to know how it was used. And that's something where we've never heard any definitive statistics about how it's been used. And as I say, depending on where you go in the country, you could have the proceedings totally open, and then you could have them transferred to a district where they'd be totally closed. And unfortunately, that's one of those areas where the media did not do a good job of protesting it for whatever reason after 9/11.
Absolutely. The irony is that in some cases, there's more access in the military courts in Guantanamo Bay than there is in the state and federal courts to these sealed cases.
Can I just respond briefly? Although I think you're right, the media and the media bar could have done a better job of addressing the material witness situation. It wasn't that the media didn't try at all. In fact, even over in the Eastern District of Virginia, when the material witness who is believed to have been Mr. Ujamaa, if I'm pronouncing his name correctly, but we couldn't even confirm which witness, formally confirm which witness we were dealing with there. When he was transferred from the West Coast to the Eastern District of Virginia for certain proceedings, I think it was Judge Lee had the matter, and when the media filed to intervene and to open portions of those proceedings, Judge Lee initially ordered that the media's application be heard in a closed courtroom and that the documents related to the application for access be taken under seal. Ultimately, he changed his mind about that, and the access proceedings, which were very brief, were held in open court. But it wasn't that there was an absence of effort, it was a failure of effort to make any headway on that score. And that's in large measure, I think, because the courts there are dealing with a statutory situation, a statutory requirement. And the problem for the public, the recipients of news from the press, is that there's no way to evaluate the propriety of that statute, that legislation, that congressionally enacted piece of the law, if you can't get information about how it's applied. And so we're in this vicious circle. We won't tell you about how we're applying the statute, we won't tell you how it works, but we expect you as the electorate to endorse that statute. And what we failed to do is to come up with a way to get out of that vicious circle.